Okay, we are on YouTube now. Good morning, everyone. Again, I am the Magistrate Court Judge assigned for this morning's calendar. Would everyone please raise your right hands? Okay, we are on YouTube now. Good morning, everyone. Here's some feedback. Again, I am. Do you swear or affirm that the information you're going to get to this court, as well as any information that you provided on your application for court-appointed counsel, is true and correct? If so, say I do. All right, you can put your hands down. This is your first appearance before the Magistrate Court of Clayton County. We are not here to try your case or to take a plea. You are here for the court to inform you of the charges against you, advise you of certain rights, set bail on those offenses for which the court is authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up that right, anything you say during this proceeding may be used against you if this case goes to trial. During this and all other proceedings, you have the following rights. You have the right to the presumption of innocence until the state proves your guilt beyond a reasonable doubt. You have the right to the indictment by a grand jury for most felonies or by accusation for misdemeanors. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine witnesses who are called to testify against you. You have the right to compel the attendance of witnesses on your own behalf by subpoena. You have the right to testify and offer evidence of your own accord should you choose to do so. However, no presumption of your guilt may be raised should you choose not to. You do have the right to have an attorney represent you. It is the policy of this court to provide each of you with an attorney. However, you can always move forward and hire a private counsel or represent yourself. Some of you will be allowed to post unrestricted bonds for your release while your case is pending. This bond may be cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond in cash together with any fees to the sheriff's office, who will hold the cash bond until your release. Until your case is done. And at that time, your cash bond will be returned. You could also use a commercial bonding company who may take up to 15% of the bond as their fee for the service. It will not be returned. You may also have someone post property as long as there is net equity in that property at least 3 times the amount of your bond. So, for example, if I set a bond of $2,000, your property must have at least $6,000 equity to qualify as a property bond. Everyone will have special conditions on your bond. At minimum, you will not be allowed to violate any laws without a bond. But some of you will have additional special conditions that prohibit you from going around certain people, going around certain places, returning to certain venues, and the court takes all of these special conditions very seriously. If you violate any special condition, you may be, your bond will be revoked. You will not be entitled to another bond, and you may be charged with additional charges like aggravated stalking, influencing a witness, or any other such charge that carries with it more heavy penalties like 10 years in prison or $20,000 in fines. So please understand that the special conditions that you are made aware of today are serious, and you shall not violate any of them. If you have any family members or friends who will be assisting you with posting bond, they should wait at least 3 hours from the conclusion of this hearing before attempting to post your bond. And that's because it takes some time for the paperwork to get to the proper channels and get processed through. Please understand that if your family member or friend is the alleged victim, he or she will not be prohibited to post your bond, as the court has put in place a no contact order. Some of you are charged with offenses for which the court is not authorized to set a bond. In that event, a bond hearing will be scheduled at a later date. If you are currently on active probation, the court is not authorized to set your bond, and that may be determined by your probation officer at a later date. Sometimes that occurs at a preliminary hearing. The purpose of a preliminary hearing is to determine if there is enough evidence or probable cause to keep you detained until your case goes to trial. If you are charged with misdemeanors only, when you come up before the court, I will ask you if you wish to waive your preliminary hearing. What that does is it moves your case along the pipeline a little bit quicker. So waiving your preliminary hearing does not affect your rights. It does not affect your bond amount. It does not affect anything. All it does, it goes from magistrate court, which is where you are now, to the next level of court. But you also have the right to have your preliminary hearing, so it's up to you. If you have felony offenses, I do not allow you to waive your felony preliminary hearing, but you do have the option of speaking with your lawyer about that. In the event you bond out, you are going to be waiving your preliminary hearing when you bond out. So keep that in mind when I ask you today, if you're going to be waiving your preliminary hearing, you may want to go ahead and move things quicker and get that signed today. The court does not have any bearing or any preference whether you waive it or not. It's completely up to you. But I want you to know that you do have that option if you are facing misdemeanors only and you are about to bond out. We're going to take the female inmates first, followed by the male inmates. And I do believe, Deputy Crawley, we have one fugitive that we need to take at the end.
Yes, ma'am, we do.
Okay.
Who is Barnett, ma'am? What's that about?
Ms. Barnett, good morning. You are charged with theft by taking and obstruction of an officer. Do you understand your charges?
Yes.
Your bond is $5,500 and you must not violate any laws out on bond. Do you understand these special conditions?
Yes.
Are you able to make bond?
No.
These are misdemeanor offenses. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing? You have to say yes or no, ma'am.
Yes.
Okay, please sign your waiver, leave it with the deputy, and your next court date will come in the mail. In the event you don't bond out and you're still in jail, they'll bring you over for that first court date, okay? All right, have a good day.
Come on, here, man. Wait, name?
Larry Camaro.
Hold on one second. Ms. Kamara, you are charged with possession of marijuana less than an ounce. Do you understand your charge?
Yes.
Your bond is $1,500 and you must not violate any laws of on bond. Are you able to make bond?
I'm not sure yet. I don't think so.
This is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes.
All right, please sign your waiver. Your next court date will come in the mail. In the event that you have not bonded out by your next court date, the jail will bring you over for your arraignment, okay? Have a good day.
Rakita English.
Give me 1 second. Ma'am, you are charged with cruelty to children in the first degree. Do you understand your charge?
Yes.
Your bond is $35,000 and you must not violate any laws while on a bond, and you must stay away from Quebec Quinlan. Do you understand your bond and your special conditions?
Yes.
Are you able to make bond?
Yes.
This is a felony offense. As such, you will not be waiving your preliminary hearing, but you can speak with your lawyer as to whether or not you need to do that moving forward. Your next court date is going to be November 10th at 8 a.m. in room 201. Have a good day.
State your name.
Give me 1 moment. Your name is what, ma'am?
Courtney Ford.
You guys can actually know, man.
You are charged with criminal damage to property in the second degree. Do you understand your charge? I can't hear you.
Yes.
Yes, ma'am.
Your bond is $10,000. You should stay away from Deontay Forest. You cannot return to 518. Is it Garden Lake or Garden Walk?
Garden Lake, but that's where me and my kids stay.
You cannot return to 518 Garden Lake in Riverdale. The court will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property, but you cannot go back to that property, ma'am, until this case is resolved or until that condition is modified by another judge. I understand what you're telling me about that being your resident with you and your children, but based on the charges, I will not allow you to go back there, and you must not violate any laws or out on bond. Do you understand, ma'am?
No, because my name is on the lease and he's agreed to leave. That's
Okay, so it sounds like when I asked you, do you understand? You're telling me that you don't agree. So I understand not agreeing, but do you understand that I'm telling you that you cannot go back there until that condition is modified by another judge or until that case is concluded?
yeah.
Okay, now you have an attorney, your lawyer can talk to the court. If he's not trying to go back there, he's moving out, by all means, let the lawyer tell the other judge that, and they may be willing to modify that. But as of now, you cannot go back there, and you have told me that you do understand. This is a felony offense. Are you able to make bond, ma'am?
What would my bond? Yeah.
It's $10,000.
Okay.
Your next court date is November 10th at 8 a.m. in room 201. Have a good day, ma'am.
Tell your name.
I am Norris.
Give me 1 second. Ms. Norris, you are charged with disorderly conduct. Do you understand your charge? I can't hear you.
Yes, ma'am.
Your bond is $1,500. You must stay away from LaToy King, and you must not violate any laws out on bond. Do you understand your special conditions? Are you able to make bond?
Okay.
Speak up.
I can't hear you.
Been paid since yesterday, 8 o'clock.
Yes or no? Yes or no?
This is a misdemeanor. Are you able to, do you wish to waive your preliminary hearing?
Yes.
Please sign your waiver, leave it with the deputy, and your next court date will come in the mail, okay? You're welcome.
Jasmine Oliver.
Give me 1 second, please. Ma'am, you are charged with DUI, improper lane change, and improper passing. Do you understand your charges?
Yes, ma'am.
Your bond is $7,000, and you shall not violate any laws out on bond. Are you able to make bond?
Yes, ma'am.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Yes, ma'am.
Thank you. Please sign your waiver, leave it with the deputy. Your next court date will come in the mail. Have a good day.
Thank you.
You're welcome.
Mr. Tucker.
Give me 1 second, please. You're charged with aggravated assault, cruelty to children in the first degree, reckless conduct, discharging a firearm near a highway, and criminal damage to property in the second degree. Do you understand your charges?
Yes, ma'am.
You do not have a bond at this time. Should you get a bond, a condition of your bond will be to stay away from Kayla Hardwick, Desiree Lee, Jordan Seaman, and Journey Pennington. However, as I said, you do not have a bond at this time. Your next court date will be November 10th at 8 a.m. in room 201. Have a good day. Give me 1 second, ma'am. You, Miss Williams,
Yes, ma'am, Nikita Williams.
you are charged with simple battery. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500. You must stay away from Phillip Hill. You cannot return to 5739 Rex Mill Terrace. It was indicated that is a shared residence. As such, you may go back with a sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without a sheriff's escort for any purpose until this case is resolved or until that condition is modified by another judge. You must also not violate any laws out on bond. Do you understand these charges and special conditions?
Yes, ma'am.
Are you able to make bond?
No, ma'am.
This is a misdemeanor offense. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
And I'm not I didn't understand exactly what that means, me waiving it, we'll move it along to what a sentencing.
Since you don't understand, I'm going to go ahead and set it for November 21st. But I explained earlier that if you waive your preliminary hearing, it moves the matter along a little bit quicker. It'll get in front of a state court judge. But because you don't understand, I'm going to go ahead and set you down for November 9th at 8 a.m. in room 201. I have appointed an attorney to represent you. He or she may come visit you and may talk to you about waiving that at a later date, or you may bond out and then it'll be waived. But for the meantime, I'm going to go ahead and set it for November 9th, okay? Have a good day.
Thank you.
You're welcome.
All right, Judge, we're going to start with the males.
Yes. Thank you.
Come on, sir. Step right there. Give your name, full names.
Cameron Shay Adams.
Yes, sir. You're charged with giving a false name. Could y'all raise the camera up and can you button your shirt, sir? I'm looking right at your chest.
Bro, I can't do it. It's broke. I can't do it, man. They don't have.
Okay. Mr. Adams, you're charged with giving a false name, no license, and following suit closely. I have dismissed your following suit closely charge, but you're giving a false name and no license still stand. Do you understand your charge?
Yes, ma'am.
Your bond is $4,500 and you must not violate any laws out on bond. Are you able to make bond?
Yes, ma'am.
These are misdemeanor offenses, which means you have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
No, ma'am.
Your next court date will be November 9th at 8 a.m. in room 201.
I'm sorry, ma'am. Yes, ma'am. Yes, ma'am. I'm sorry.
You're gonna waive it?
Yes, ma'am.
Please sign your waiver, leave it with the deputy. Your next court date will come in the mail, okay?
Yes, ma'am.
Have a good day.
Yes, ma'am.
Come on
Thank you.
this way, sir. Come on.
Thank you.
Look forward, sir. Stand right there. Wait for the judge.
You're Mr. Allen. You were charged with aggravated assault. Do you understand your charge?
Yes, ma'am, but it was not my fault.
I'm not asking, are you guilty or innocent, sir? That will occur at a later date. I'm just asking, do you understand the charge for which you are facing aggravated assault? Do you understand it?
Yeah, I did. He attacked me.
Once again, this is not the appropriate time for you to tell your defense. I'm asking, do you understand that you are charged with aggravated assault? If you answer no, I can read to you what is alleged. If you answer yes, then we can move forward. I'll ask you once more, do you understand your charge, aggravated assault?
Yes.
All right. You do not have a bond at this time. Should you get a bond, the condition of that bond will be to stay away from Charles Norman. This is a felony. As such, your next court date will be November 10th at 8 a.m. in room 201. Have a good day.
Come on this way. Come on this way. Come on.
I understand, sir. Mr. Allen, I understand what you're saying, and it is important, but this is not the appropriate time to share your defense. I have appointed an attorney to represent you. That's where you will share your defense with your attorney, and they will make the appropriate motions, tell the appropriate parties, whatever's going on. So I'm not wanting you to feel like I'm not hearing you. It's just not important at this juncture, and it's not appropriate at this juncture to share your defense because your lawyer's not here, the prosecutor's not here, none of that, right? So we're going to cut this short for anybody else that's listening. We're not going to be talking about who did what or whatever because it's not appropriate at this juncture. While it may be true, it's not appropriate here. Okay. You have a lawyer, he or she will come visit you and you can discuss that further. Okay. Have a good day, sir.
Hi, good afternoon. I'm Hananiah Augustine.
Give me 1 second. Mr. Augustine, you are charged with battery. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500. You shall stay away from Alicia Williams. You shall not return to 1107 Marquise Way. It was indicated that that is your shared residence. As such, I will allow you to go with the sheriff's escort for the limited purpose of retrieving your personal property. However, you may not go back to that property without a sheriff's escort for any purpose until this matter is resolved or until this condition is modified by another judge. You must also not violate any laws or out on bond. Do you understand the conditions of your bond, sir?
Yes, ma'am. Where do I live?
I can't hear you.
I said yes, ma'am, but should just shack up my relative?
Should what?
I said yes, ma'am. I understand the charges, but just shack up my relative or something. We have a family here. That's where I live.
Okay, as far as where you're gonna live, I'm not sure about that, but the court cannot allow you to go back based on my review of the warrantless arrest affidavit. It is not appropriate for you to return to that property. So where you live, I'm not sure, sir, but I did have appointed an attorney to represent you. My question was, do you understand the conditions? And you do understand those. Are you able to make bond?
Yep.
This is a misdemeanor. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing?
Speed up the bond?
Your bond is the same. It's not going to speed up the bond. And I'm not going to say this another time. So if anybody can hear me, what the preliminary hearing does is it determines whether or not there's enough probable cause to keep you detained. Because you have a misdemeanor, you can waive that preliminary hearing and move the matter past magistrate court because that bar is a little bit lower. So you're going to move it past magistrate court and go to state court. If you bond out, that hearing is already waived. Okay. So I'll ask you once more, do you wish to waive it or not? Just let me know and I'll set it down for a hearing. If you don't understand and you're not sure, we'll set it down. You can speak with your lawyer about whether or not you want to waive it.
I wish to waive it.
Okay, please sign your waiver, leave it with the jail, the deputy right now, and then your next court date will come in the mail. Since you said that your address is this one, you need to make sure they have an updated address on file because you're not going to be able to go back here regularly to check your mail or anything like that. So give them an updated address where they can send you your court date. Okay, sir?
Gotcha.
Thank you. Have a good day.
Marcellus Brooks.
Good morning. Give me 1 second. Mr. Brooks, good morning. You are charged with reckless conduct. Do you understand your charge?
Yes, ma'am.
Your bond is $10,000. You should stay away from Destiny Manning. You shall not return to 4200 Stillwell Drive in Rex, and you shall not violate any laws while out on bond. Are you able to make bond?
Yes, ma'am.
This is a misdemeanor. You have the option of waiving your preliminary hearing. Do you wish to waive your preliminary hearing? Please sign your waiver. Your next court date will come in the mail. Have a good day.
Robert Brooks Chandler.
Robert Chandler? You're Mr. Chandler? Okay, give me 1 moment. Sir, you were charged with battery. Do you understand your charge? It is alleged that you struck Terry Yvette Hurd in the back of the head, causing her to trip over the rug and run into the wall, striking the front of her head, causing a gash in the middle of her forehead. Bleeding occurred from this incident that caused her EMS to come to the scene to treat her. That is what is alleged. Your bond is $3,500. You shall stay away from Ms. Hurd. Do you reside at 7315 Mockingbird Place with her?
No.
You shall not return to 7315 Mockingbird Place. And you shall not violate any laws out on bond. Do you understand these special conditions? You say yes, ma'am? Okay. Are you able to make bond?
So,
You said you think so?
yeah, I gotta get in touch.
This is a misdemeanor. Do you wish to waive your preliminary hearing?
Yes, ma'am.
Please sign your waiver. Leave it with the deputy. Your next court date will come in the mail. Have a good day. Did Mr. Easton bond out?
I'm right here. I paid the bond. My family came and paid the bond yesterday morning around 10 a.m.
Miss Wesley, can we put him back for a second? Miss Wesley, can you check on the status of Mr. Easton? I didn't see the paperwork sent over to me. Miss Wesley, if you got that, just send me a message because I know you had some internet issues, so want to make sure you heard that. Just shoot me a chat that you got that request, if you don't mind. And good morning to you. I don't think I said good morning to you today. Mr. L,
Yes, ma'am.
you are charged with loitering. You're also charged with possession of marijuana less than an ounce, possession of firearm by a felon, and altering the ID of a firearm. Do you understand your charges? You do not have a bond at this time. Your next court date is November 11th at 8 a.m. in room 201. Have a good day.
Andres Fernandez.
Give me 1 second. Thank you, Ms. Wesley. Just let me know what the update is on that. Are you charged with loitering or prowling? Do you understand?
Yes.
Your bond is $1,000. You must stay away from Marks and Lara. You must not return to 7223. Call your way, and you must not violate any laws on bond. Do you understand these conditions?
Yes, ma'am.
Are you able to make bond?
Yes, I will.
This is a misdemeanor. Do you wish to waive your preliminary hearing?
Yes, to make it go faster.
Please sign the waiver. Leave it with the deputy. Your next court date will come in the mail. Have a good day.
Thank you.
You're welcome.
Good morning, Your Honor. It's Michael Kings.
Good morning. Give me 1 second. Mr. Haynes, you're charged with theft by shoplifting. Do you understand your charge?
Yes, ma'am.
Your bond is $10,000. You shall not return to the Home Depot on Lamar Hutchinson, and you shall not violate any laws of auto bond. Do you understand?
Yes, ma'am.
Are you able to make bond?
Yes, ma'am.
This is a felony. As such, you cannot waive your preliminary hearing at this juncture. Your next court date will be November 10th at 8 a.m. in room 201. Have a good day. Thank you.
Good morning, Your Honor. My name is Hunter Kincaid.
Good morning. Give me 1 second. Mr. Kincaid is charged with impeding the flow of traffic, possession of marijuana less than an ounce, and a felony count of violation of the Georgia Controlled Substances Act. Do you understand your charges? Your bond is $8,000, and you must not violate any laws of auto bond. Are you able to make Bond? Your next court date is gonna be November 10th at 8 a.m. in room 201. Have a good day.
Good morning, Your Honor. Brian Lawson.
Good morning. Give me 1 second. Mr. Lawson, you're charged with a felony count of theft by taking. Do you understand your charge? Your bond is $25,000. You must not violate any laws of auto bond. Are you able to make bond? Are you able to make bond? Okay, I couldn't hear you. Your next court date is gonna be November 10th at 8 a.m. in room 201. Have a good day.
Travion Lee.
Good morning. Are you Mr. Lee?
Yes.
Are you Mr. Lee?
Yes.
Okay, give me 1 second. You're charged with attendant window violation, open container, possession of marijuana less than an ounce, and use or possession of drug-related objects. Do you understand your charge? Do you understand your charges?
And what was the last one?
You're charged with tinted window, open container, possession of marijuana less than an ounce, and use or possession of drug-related objects. Do you understand your charges? Your bond is $4,000 and you must not violate laws of auto bond. Are you able to make bond?
Yes.
These are misdemeanor offenses. Do you wish to have your preliminary hearing?
You can wait.
I can't hear you.
You can wait.
I'm sorry, say that again.
Yes.
Okay. Please sign your waiver. Your next court date will come in the mail. Leave your waiver with the deputy. Have a good day.
Good morning, Judge Dave Lindsay.
Good morning. Give me 1 second. Mr. Lindsay, you are charged with possession of marijuana less than an ounce. Do you understand your charge?
Yes, ma'am.
Your bond is $1,500. You must not violate any laws of auto bond. Are you able to make bond?
Yes, Judge.
Do you wish to have your preliminary hearing as it is a misdemeanor?
Yes, ma'am.
Please sign your waiver. Leave it with the deputy. Your next court date will come in the mail. Have a good day.
And Judge, can I ask you a question?
Yes.
With the bond, if it was posted yesterday, would you know about it or?
No, sir. They brought you up in front of me today, so that's why we did your first appearance. But it's the same that was preset, so you should be okay.
All right, thank you.
You're welcome.
Next man.
Mr. Reed, your charge is terroristic threats. Do you understand your charge?
Yes, ma'am.
Your bond is $20,000. You should stay away from Ardena Woods. You shall not return to 616 Flint River Road, and you must not violate any laws of auto bond. Are you able to make bond?
20,000.
Yes, sir.
Yes, ma'am.
This is a felony count of terroristic threats. As such, your court date is scheduled for November 10th at 8 a.m. in room 201. Have a good day.
You too.
Good morning, Kyle Robinson.
Good morning. Give me 1 moment. Mr. Robinson, you're charged with driving on an expired tag and possession of marijuana less than an ounce. Do you understand your charges?
Yes, ma'am.
Your bond is $2,000. You must not violate any laws of auto bond. Are you able to make bond?
Yes, ma'am.
These are misdemeanors. Do you wish to have your preliminary hearing?
Yes.
Please sign your waiver. Your next court date will come in the mail. Have a good day.
Thank you.
Good morning, Your Honor. Diego Vázquez.
Good morning. Give me 1 second. Mr. Vasquez, you're charged with simple battery. Do you understand your charge?
Yes, ma'am.
Your bond is $3,500. You must stay away from Martha Garcia. Do you reside with Ms. Garcia at 9264 Deer Crossing?
No, that's a different address.
You said what?
She lives in a different address. That's my address.
Where does she live?
I don't know her address separated. I'm not sure where it's somewhere. I don't know her address, man. Yeah.
So wherever she lives, you know to stay away from her, correct? And you're telling the court that she does not live at 9264 Deer Crossing Drive.
That's my parents' house.
You must not violate laws out on bond. Do you understand that? All right. Are you able to make bond?
Yes, ma'am.
This is a misdemeanor, which means you have the option of waiving your preliminary hearing. Do you wish to do that?
Yes, ma'am.
Please sign the waiver, leave it with the deputies, and your next court date will come in the mail. Have a good day. Thank you. We should have only one person left, right? That's Mr.
Yeah, the fugitive.
Yes.
Yeah, come on, sir. Start right here. We're gonna check when you're done with it.
Are you Mr. Von Ellinger?
Yes, Your Honor.
Sir, you are here for what is called an extradition hearing. All of the rights which I advised everyone of earlier also apply to your case, but your hearing is a little bit different in that you do not have any charges pending against you here in the state of Georgia or in Clayton County. You've been brought to court today because you have charges pending against you in another state, and they are requesting that you return to that state to answer to those charges. Are you in fact Aaron Von Ellinger?
Yes, Your Honor.
Do you already have an attorney representing you in this matter?
In the state of Idaho, yes, Your Honor.
Okay. You are charged with being a fugitive from justice as follows, in that you did enter and remain in the state of Georgia, knowing that he, Aaron Von Ellinger, is wanted by 88 County Sheriff Office, Idaho, for rape under warrant CR01-21-34639, a felony, and they have indicated that they will extradite you. You're being charged, and this hearing is being conducted pursuant to OCGA Title 17, Chapter 13. As you have been heard, it is alleged that you were charged with rape in the state of Idaho, and they want you to return. You have a choice as to whether you wish to contest extradition or to waive extradition and be returned to the other state without going through a formal extradition process. If you decide that you wish to contest extradition, the court may commit you to the county jail for an initial period of 30 days. During that time, a warrant will be prepared under the governor's signature for your extradition to the other state. The court may consider allowing you to post a bond, but the court is not required to allow bond in your case. As you are wanted by another state, I am not setting a bond in your case at this time, so any request for bond is denied. If you do not wish to voluntarily return to the state of Idaho, you may file a writ of habeas corpus to contest the extradition. The writ of habeas corpus can only contest 4 things. 1, whether the extradition documents are in order on their face. 2, whether you are charged with a crime that actually exists in the state of Idaho. 3, whether you're the person named in the request for extradition. And 4, whether you are in fact a fugitive from justice. You cannot contest the issue of your guilt or innocence in this state. You are entitled to the advice of counsel in contesting extradition or deciding whether to waive. If the state is unable to extradite you within 30 days, you may be committed to the county jail for an additional 60 days awaiting your extradition. If the extradition is not completed in 90 days, then you will be released. So I have to ask you, do you wish to waive extradition and voluntarily return to the state of Idaho to handle these charges?
Yes, Your Honor. I do not wish to contest it.
Okay. There are several original waivers that will be before you that you need to sign each of those. The jail will return them to me. I will sign them today, and that will get the matter moving along to try to get you out and get you returned, because they said they want to come get you and get that process moving along, okay?
Yes, Your Honor, thank you.
Thank you.
Come on, Dave, as well.
Ms. Wesley, do we have an update about the
Easton?
other gentleman? Mr. Easton?
Yeah.
Or Azure or somebody, can y'all check and see what's going on with Mr. Easton? Is he out? Is he?
Okay, Judge, we're checking.
Thank you. I see Ms. Murphy is on here as well. She's with intake. Somebody should be able to get me an answer if you don't mind, so we can conclude this calendar quickly. But I don't want him to be here and not do his first appearance, especially on these charges. So we need to get an answer. I'll stand by for somebody to give me an answer.
You do have a right to remain silent. Anything you say can be used against you. These proceedings are being recorded, so wait and speak to your attorney in private about the facts of your case. You have a right to be in contact with your attorney or your family by telephone from the jail. If you're here on a warrant, the judge who issued the warrant has either set a specific bond amount or no bond, and you'll usually need to go back before that judge in order to modify the bond. I will review each case, however, to make sure the warrant was not issued in error. If you are appointed an attorney to represent you, there is a $50 assessment that you'll be ordered to pay. You'll be given time to pay that off for their services. And there could be an additional assessment at the end of the case. You'll be given time to pay that as well. Everyone that's here for court this afternoon, please raise your right hand. Raise your right hand. Do you all swear or affirm testimony you give will be the truth, whole truth, and nothing but the truth, so help you God? All right, you put your hand down. Let's call your name. Please step up to the podium, actually to the microphone. Richard Strong. Ms. Strong, it looks like you're arrested for violation of an injunction. I'll find probable cause for your arrest. Are you able to hire an attorney?
I have an attorney, yes.
Well, you don't on this case. Are you going to hire one?
I'm sure she'll add it to it. This is, I'm a little confused on this case. I've been here for over a year, and this is the original complaint, so I don't.
All right. Well, I'm trying to find out if you have an attorney or not. So you don't have an attorney on this case yet. Are you able to hire an attorney or not?
Yes.
Okay. All right. I'll find you're able to hire your own attorney. I'm going to set your bond at $20,000. No contact with your wife, and obey any injunction. Your next court date is going to be October 21st in front of Judge Jacobus in Vieira. All right. Good luck. Haley Davies. Miss Davies, it looks like you're here on 2 out-of-county warrants from Charlotte County. Both of these have a $15,000 bond, and we're going to set a control date. And the date on my docket is not correct. I believe that's supposed to be October 6th instead. We'll see you back on October 6th only if Charlotte County has not picked you up before then or you haven't bonded out. All right? It's just a control date to make sure they take care of it. All right? Good luck.
Thank you.
All right, Erica Crane. Hi, Ms. Crane. It looks like you were arrested for a retail theft. I'll find probable cause for your arrest. Are you able to hire an attorney?
No.
All right, I'll appoint the public defender's office to represent you.
I had a question. Is there a way that you can get the bond lowered? Because I just had eye surgery.
Yeah, I'm not likely to do that because I'm looking at your prior history of theft convictions. So
Yeah.
I think I'm going to leave it as is. It's only $500 though, instead of increasing it. You're not to return to the Home Depot store on Malabar Road in Palm Bay. Your next court date's October 18th, in front of Judge Jacobus in Vieira. Good luck,
Thank
Mrs.
you.
Craig. Sarah Hopping. Hi, Ms. Hopping. It looks like you were arrested on 3 counts of possession of controlled substance without prescription and possession of drug paraphernalia. I'll find probable cause for your arrest. Are you able to hire an attorney?
No, sir.
All right, I'll appoint the public defender's office to represent you. I'll reduce the bond somewhat, but on the 3 felony counts, I'll reduce them in half to $1,000 each. Leave the bond at $500 on the paraphernalia. Your next court date is October 19th, in front of Judge Atkin in Vieira. All right, good luck.
Thank you.
Helene Murray. Hi, Ms. Murray. It looks like you were arrested for battery on a person in custody. This was a capious arrest with a $5,000 bond. Are you able to hire an attorney to help you with this?
No.
Okay, I'll appoint the public defender to represent you. I assume you were already in custody for something anyway, right?
Yes.
Okay. All right, your next court date is October 21st in front of me, Judge Friedland in Titusville. Good luck, Ms. Murray. Molly Vargas.
Hello.
All right. Hi, Ms. Vargas. It looks like you were arrested for a domestic violence battery. I'll find probable cause for your arrest. Can you afford an attorney to help you with this?
I am already covered by Alpizar Law, sir.
Okay, so you don't need me to appoint anybody.
Well, I need to get out of here because I had been illegally detained.
Okay, well, I'm trying to find out if you need an attorney appointed or not. First.
Yes, Alpizar Law. Cynthia is, I was physically hit by a car this year on my bicycle.
Yeah, but we're talking about someone representing you on this criminal case.
I wasn't a criminal. They told me to walk around the block.
This is a domestic violence battery criminal charge. That's why you're in jail.
I didn't even do anything.
They arrest people for criminal charges, generally.
I'm not a criminal. I actually was a hero during the pandemic.
All right, Ms. Vargas.
I'm a personal carry.
Are you going to hire your own attorney or not?
Yes, I am going to hire Alpizar Law.
Right, they don't handle criminal cases.
They don't?
Not usually. They usually handle civil personal injury.
Okay, sir. I will
So
draw.
I just want to make sure.
Yes.
If you can't hire an attorney, I'll appoint one to represent you.
Yes. Can we do that, please?
All right. I'll appoint the public defender to represent you. So, Ms. Vargas, I'm probably going to release you on this and give you a court date to show up in court. Will you show up?
Yes.
All right. Can you avoid getting into any confrontation with Mr. Konstantinos?
Venizelos? Yes. He should have been my husband already.
All right. Well, I'm not sure why you got arrested for this, but you did. So I'm going to release you on your own recognizance. Yes. Your next court date is October 18th, front of Judge Jacobus in Vieira.
Will I get the paperwork to that?
Yeah, we're going to give you paperwork for that.
Awesome.
And here's the, yes, I'm sorry.
I'm getting released today, right? Correct.
Yes, hold on. Hold on. The state is going to say,
I should be in the hospital right now because my spine hurts from the injury.
Okay, hold on one second. What says the state?
The state has been in contact, the victim has been in contact with the state. He's not afraid of the defendant. He'd like no unconsented contact, and it's okay if she returns home.
Yes. Yay.
All right. Well, I'm just going to release you on your own recognizance with no conditions. But Ms.
no
Vargas,
contest.
Just don't do anything to get yourself rearrested. All right.
Okay.
All right, good luck to you.
Thank you so much.
All right. All right, Craig Hubbard.
Good afternoon, Your Honor.
Hi, good afternoon, Mr. Hubbard. It looks like you're here on an out-of-county warrant from Lee County. You do have a bond amount of $383. We're going to set a control date for October 6th for Lee County to come pick you up if you haven't bonded out before then. That's only a control date to make sure they either pick you up or you bonded out, one of the two. Okay?
Yes, sir.
All right. And if you do bond out, you need to get this taken care of in Lee County so it goes away.
Yes, sir.
All right. Good luck to you.
Thank you.
All right. Michael Denton. All right, let's see, just one second, Mr. Denton. All right, so it looks like you were arrested on a charge of trespass at a Cumberland Farms in Cocoa. I'll find probable cause for your arrest. Are you able to hire an attorney?
No, sir.
All right, I'll appoint the public defender to represent you. I'll reduce your bond to $250, no return to the Cumberland Farms. Your next court date's October 18th, in front of Judge Jacobus in Vieira. Good luck.
Your Honor.
Oh, I'm sorry. Yes.
I'll let Mr. Gittens go first.
I would actually defer to you. I would ask for your stipulation on a release.
I'm sorry?
I'm asking the state if they would stipulate to a release. We received an email that Mr. Denton has a Baker Act pending, and upon release, he would be sent for the Baker Act.
Okay, I wasn't aware of that. All right, so what's his estate?
No objection.
All right, I will go ahead and release Mr. Denton on his own recognizance. Mr. Denton, don't go back to the Cumberland Farm store. You understand?
I understand.
All right, and get in touch with the public defender so they can help you with this. Your next court date's October 18th. Good luck to you.
Thank you.
All right, Joseph Standish. Joseph Miles Standish.
Uh-huh.
All right, Mr. Standish, it looks like, just one second.
All right.
All right, looks like you were arrested for trespass at another Cumberland Farms, and you also arrested for possession of drug paraphernalia.
Right.
I'll find probable cause for your arrest. Are you able to hire an attorney?
No, sir.
All right,
I didn't even know I had the paraphernalia, being charged with paraphernalia until now. They didn't even tell me that.
All right.
Okay.
Anyway, all right, I'm going to set your bond $250 on each count instead of $500. So your total bond's $500. You're not to return to the Cumberland Farms on Apollo Boulevard in Melbourne. Your next court date's October 18th, in front of Judge Jacobus in Vieira. Good luck. All right, and the next one's going to be Joseph Mungo. All right, and just one second, Mr. Mungo. I'm going to catch up on some paperwork, and I'll be right with you.
Are you still having fun?
We're on the record.
You are then.
Yeah. All right, Mr. Mungo. Hold on one second. All right. So Mr. Mungo, it looks like you're here on an out of county on-site violation of probation from Indian River County with a no bond status. We're going to set a control date for October 6th. We'll see you back at that time only if Indian River County has not picked you up. Is there any other hold on that, AMA or anything?
No, Your Honor.
Okay. All right. Good luck, Mr. Mungo.
Thank you.
All right. Nelson Serrano. All right. Hi, Mr. Serrano. So you have two matters on the docket. It looks like you're arrested pursuant to an arrest warrant on charges of burglary of a dwelling while armed, grand theft of firearm, possession of firearm by convicted felon, and you also have an out-of-county on-site violation of probation out of Hillsborough County. As a result of that, we're going to leave that set at no bond, and that'll just act as a hold on you till your local charges are disposed of. The warrant came in on the new local charges with no bond until first appearance. And so on the burglary charge, I'm going to set your bond at $100,000. On the grand theft of firearm, $5,000. On the possession of a firearm by convicted felon, $15,000. And there are conditions on the warrant: no contact with any victim or return to the location of the offense. And your next court date's October 21st, in front of me, Judge Friedland in Titusville. Good luck, Mr. Serrano.
And Your Honor, he is
He's what?
he's AMA.
Okay, so on the out-of-county matter, let's make a notation that he, under the Anti-Murder Act, he has to be held on a no bond status. So you can't be released on the Hillsborough County matter until your case is disposed of in Hillsborough County. All right? Good luck.
Judge, did you appoint the public defender?
Oh, I'm sorry, I did not. Mr. Serrano, are you able, let's bring him back. Sorry about that.
I'm getting a lawyer, sir.
Mr. Serrano, are you able to hire an attorney?
Yes.
Okay, you sure?
Yes.
Okay, I'll find you're able to hire your own attorney. Good luck to you.
Thank you.
All right, Anthony Bell. Yeah, let's see. All right, Mr. Bell, it looks like you were arrested for driving while license suspended or revoked as a felony. I'll find probable cause for your arrest. Are you able to hire an attorney?
No, sir.
All right, I'll appoint the public defender to represent you. Your bond is $2,000. It looks like you have a pending similar case, except it's a misdemeanor. Your next court date is October 19th, front of Judge Atkin in Vieira. All right, good luck.
Thank you.
Alan Drain. Hi, Mr. Drain. It looks like you're arrested for possession of a controlled substance without a prescription and 3 counts of paraphernalia. I'll find probable cause for your arrest. Are you able to hire an attorney?
No, sir.
All right, I'll appoint the public defender to represent you. Your bond's $2,000 on the felony. I'll leave it at $500 on the first paraphernalia and release you on your own recognizance on counts 3 and 4. So you're only being held on 1 paraphernalia and the controlled substance. Your next court date is October 19th, front of Judge Atkin in Vieira. Good luck. Jason Moore.
Judge, he refused to come to court.
Okay. Since Mr. Moore refused to come to court, just leave everything as is and continue him over until tomorrow. All right, Robert Nelson. Hi, Mr. Nelson. It looks like you were arrested for violation of an injunction. I'll find probable cause for your arrest. Are you able to hire an attorney to help you with this?
No, sir, I'm not. But I
All
don't.
right, I'll appoint the public defender's office. I'm sorry?
No, I'm listening.
Okay. I'll appoint the public defender's office to represent you. And I'm probably going to go ahead and release you on this. Actually, I'm not sure that there's, hold on one second. I'm not sure there was really probable cause for his arrest on this because he hadn't, it looks like he had not yet been served with the temporary injunction, from what I can see. So, but you have been served now with notice, with the injunction and a notice of a hearing. There's a hearing September 30th on the injunction, right?
Yes, sir. They gave me that paper yesterday.
So in other words, right now the injunction's in effect. You know, if I release you, you need to abide by the injunction. You understand?
Yes, sir, I do.
All right, which means the injunction says no contact of any kind. Don't go within 500 feet of her. Okay?
Yes, sir.
Okay, and you're not to possess any weapon of any kind. All right? So whatever the injunction says, that's in place as of right now. Okay?
Yes, sir.
All right, I'm going to release you on your own recognizance since you hadn't been served with injunction at the time that this occurred. And your next court date is October 18th in front of Judge Jacobus in Vieira. So this case, this, just, you know, if you weren't served, this case will probably end up getting thrown out. But if you do something from this day forward, they're going to prosecute you for that. You understand?
Yeah, I understand. The case you're talking about that's being thrown out, it was scheduled for the 30th of this month?
Yeah, that's a hearing to determine whether the temporary injunction should be kept in effect permanently or for any other length of time, or whether it should be dismissed.
So now this one that we're speaking of now, is this a temporary injunction as well?
Yes, it's violation of a temporary injunction that's temporarily in place until your hearing on September 30th, next week. Okay?
The information I have indicates he was served.
Well, he was just served with a notice yesterday or today.
No, he was, according to this, he was served. Service date was on August 23rd of 2021 on the temporary.
Hold on a second. I didn't see that. Hold on.
I've never received any paperwork until I came to jail.
Because even as recently as August, they were still trying to get him served.
But do I show up for court on the 30th?
Yeah, if you don't, they're going to keep the injunction in effect if she shows up.
Okay.
And says keep the injunction in effect. So that's your chance to be heard. But hold on, Mr. Nelson. Let me go back and look because I didn't see what the state is suggesting.
It indicates that it was validated on the 14th of September. So I don't know. It's maybe inconsistent with what you have there. But
the 14th of September, I was supposed to be here in Florida for court, but I was in PA and I had a heart attack and I notified the court.
That he didn't get served until yesterday.
Okay.
They had previously just kept the temporary injunction in effect to try to get him served. As recently as August 17th, they issued a new temporary injunction to try to get him served and sent it to the sheriff to try to serve him. So I don't see that. But anyway, so I'm releasing you, Mr. Nelson, with the understanding the temporary injunction is in effect. No contact. Don't go within 500 feet. Okay?
Okay.
And if you violate the injunction, you know, they'll charge you with that and they can probably, you know, convict you of it if there's evidence. This one will probably get thrown out, so don't cause yourself any other problems.
All right, sir.
All right, good luck to you.
Mm-hmm.
All right, Marco Quiroz or Alana?
Judge, Mr. Quiroz is going to need the language line Spanish.
Okay. Are you aware of anybody else that might need it? Just or don't know?
No, I am not, Judge. Not aware.
Okay. All right. Let me I can't remember, I know I've asked this before, Madam Clerk, are you at the jail, are you able to contact them, or should I do it here from here?
Do you want us to call the language line or try the interpreter?
I'm sorry, I keep forgetting we have our own interpreter now. I just have Mr. Caroz or Alana stand by, and I will have to email the interpreter and see if she can jump on to Teams. Hold on one second. And as soon as she is available, we'll take his case. Where is it? Here it is. All right, so I'll hear back from her sometime, and then we'll just hold on to this one until we're ready. All right, we'll come back to that. James Toomey. All right, just 1 second, Mr. Toomey. It looks like you're back on a violation of probation. This was you were on probation for grand theft of a motor vehicle. Looks like the warrant set the bond at $5,000. Is the state aware of any basis for a no bond hold instead?
No, Your Honor.
All right, we'll reset it back to $5,000. Are you able to hire an attorney, Mr. Toomey?
No, sir.
All right, I'll appoint the public defender, and your next court date on this is October 21st, in front of Judge Davidson in Vieira. Good luck to you.
Thank you.
All right, George Lozada. This is a council review, it looks like. All right, Mr. Lozada, this is a violation of probation case where you're on probation for a battery, and you're not currently represented by an attorney. Can you afford an attorney?
No, sir.
All right, you want me to go ahead and appoint one?
Yes, please.
All right, I'll appoint the public defender to represent you, and you already have a court date next week, September 29th. I
Yes.
believe that's next Wednesday. All
Okay.
right?
Yes, sir.
And that's in front of Judge Brown in Vieira, and they'll transport you for your hearing, and the public defender will represent you. Okay?
Thank you, sir.
All right, good luck.
Thanks.
All right, and that should be all of the second group.
Yes, Judge, we just need some time to get the next group in here.
Okay, sounds good, and I'm still waiting to hear back from the interpreter anyway. All right, so if you'll just keep Mr. Caroz or Alana in court, and then we'll take a break till we're ready to go on the next group.
Thank you, Judge.
Could you please be seated? Sir, in the middle there, is there a reason you didn't raise your right hand? I can't hear him.
He said he did.
He said he did?
Yes.
Okay. All right. All right, good morning. My name is Kelly Ingram. I'm a county court judge here in Brevard County. You're here this morning for initial appearance. There's 3 purposes for today's hearing. 1, to determine if there's probable cause for your arrest. 2, to determine how you would like to proceed regarding an attorney. And 3, to set an appropriate reasonable bond in your case. What is probable cause? Probable cause means 2 things. 1, a crime has been committed, and 2, you're likely the individual that committed that crime. Unless I state otherwise, I'll find probable cause exists. If I do not find probable cause exists, 1 of 2 things may occur. I may release you on your own recognizance for that charge. That does not mean that the charges are dismissed. It simply means you will not be held in custody on that charge. Or the assistant state attorney may ask for an additional 24 hours to provide some evidence or facts that may or may not establish probable cause. If they do so, I likely would give them that opportunity. The second purpose for being here today is to determine how you would like to proceed regarding an attorney. You have an absolute right to have an attorney represent you through all stages of the criminal proceedings. If you cannot afford one, the court can appoint one for you. There is a $50 application fee for that. That certainly does not need to be paid today. And at the resolution of your case, either with a guilty verdict or by entering into a plea, there would be an additional nominal fee charged. The third purpose for being here is to set an appropriate reasonable bond. You likely have come in with a certain bond amount set. The court may increase that bond or decrease that bond depending on different facts and circumstances. If you have come into custody on an arrest warrant, very likely the bond amount scheduled on your arrest warrant will remain the same. If you want that modified, you would motion your trial judge for a bond modification hearing. You do have the right to remain silent. Everything you say today is being recorded and can be used against you at a later time. Today is not the day to discuss the facts and issues of your case. You may say something that you believe is in your best interest and perhaps it's not. Ma'am, if you could sit up, please. Thank you. You may say something that you believe is in your best interest and perhaps it's not in your best interest. So long as the jail staff allows, you should be able to use the telephone to contact your family, your friends, and your attorney. So as I call your name, I'll ask if you please step forward. Excuse me. Lisa Saxon. Hey, good afternoon. Yeah, good morning. What is your name?
My name is Lisa Saxon.
Okay, Ms. Saxon, you are here for no motor vehicle registration and 1 count of use of possession of drug paraphernalia. We didn't get a PTR sheet for her? Okay. I do find probable cause for your arrest. Do you intend on hiring an attorney?
I don't know if I can afford an attorney.
Okay, so you have 2 choices. You can ask to have one appointed today, and then at a later date, you can hire an attorney if you have the ability to, but there would be that $50 application fee. Or you can wait, see if you can hire an attorney, and if you can't, at any point, you can ask for a court-appointed attorney.
Do I need an attorney today?
Well, that's up to you. Mr. Gittens, I'm gonna set her bond at $500 for each count. Do you have the ability to pay $1,000?
I might have somebody that could help me out.
Right. Mr. Gittens, do you have a PTR sheet for her?
No, I don't have one either.
No, neither do I. So I'll set your bond at $1,000. That would remain the same whether you have an attorney or not today. So you can determine, and then I'll give you a next court date for an arraignment. If you determine you can't afford to hire an attorney, at that date you can ask for a court-appointed attorney.
Okay.
All right, so I'll set your bond at $500 for each count. So it's $1,000. And your next court date is October 11th at 9 a.m. with Judge Garagoslo.
Okay.
All right, thank you.
Yes, ma'am.
Cynthia Stevens. Okay, Ms. Stevens, you're here on 2 cases for failing to appear for jury trial on both of your cases. Would you like me to reappoint the public defender to represent you?
Yes.
All right, I'll go ahead. Are you feeling all right?
No.
No. I'll go ahead and appoint the public defender to represent you. Your bond will remain at no bond, and your next court date for both cases is October 13th at 9 a.m. All right, thank you. Good luck to you. Okay, who's next?
Ma'am,
Dan Quinn
Ms.
Chang?
Chang,
Her bond has been dropped, surety bond.
Oh, she's surety bonded?
Yes.
How did she do that?
She's the one who's not.
She
Oh,
couldn't have.
I'm sorry, correction, ma'am. She's,
She's what? I can't hear you unless you talk.
She's unable to come to court today.
Okay.
She'll have to come tomorrow.
Okay, so we'll reschedule her for tomorrow.
Yes, ma'am, sorry.
Okay, thank you.
Morris is next.
Okay. Okay, good morning, ma'am. What is your name?
Kendra Morris.
Okay, Ms. Morris, you are here on a violation of probation warrant. Mr. Dressler, does she qualify for any special classifications? Can you see that assistant state attorney down there?
Yes, ma'am.
Oh, that means you can see me too.
Yes, ma'am.
Okay, so that's just really weird to see me here and there. So sorry, Mr. Dressler, you're losing my face. Okay. You're on mute, sir.
I didn't even realize it was muted. I apologize. Your Honor, she does not qualify for a hold under the Anti-Murder Act or Jessica Lunsford Act. However, Your Honor, she is on felony probation. Therefore, we would be requesting a no bond hold at this time.
Okay, this is an arrest warrant with a no bond. If for some reason Judge Ballou changes your bond, she's asking that you report to probation within 48 hours. All right, so your next court date is going to be October. Actually, it's not Judge Ballou. It's Judge Brown.
Okay.
It'll be October 22nd at 9 a.m. with Judge Brown.
All right, thank you.
Okay. All right, thank you. Oh, no. Do you intend on hiring an attorney?
No, ma'am.
Would you like me to appoint one?
Yes, please.
Okay, I'll appoint the public defender. Sorry about that.
Thank you.
Thank you.
Your Honor,
Mr. Dressler, did you say something?
I'm just trying to find her PTR sheet. I don't know if one was created for her.
It probably was not because there was a warrant.
Okay.
Okay, we have Francia
Your
Cabrera.
Honor.
Oh, she's surety bonded?
Yes, ma'am.
Mary Eichert. Okay. Good morning, ma'am. What is your name?
Mary Eichert.
Okay, Ms. Eichert, you are here on a violation of probation. Do you intend on hiring an attorney?
I can't afford to.
Would you like me to appoint one?
Please.
All right, I'll appoint the public defender to represent you. And your bond will remain at no bond.
And Your Honor, just for the record, she qualifies for a no bond hold under the Anti-Murder Act. So we would agree with that, a no bond hold.
Okay, thank you. That's important because we need another day, court date, because we'll send you straight to a BOP hearing and skip the arraignment.
Judge, can I ask the qualifying offense?
Yes, Mr. Dressler, you had the qualifying.
Honor, she has an aggravated battery conviction from 2009 here in the state of Florida.
Thank you.
Her next hearing date would be October 19th at 1:30 p.m. in front of Judge Koenig.
Thank you.
Thank you.
And that was on a warrant, I take it, correct?
Yes.
Okay, so there wouldn't be a PTR. All right.
Deborah Hale.
Yes, ma'am.
Okay, what is your name?
My name's Debbie Hale.
Okay, Ms. Hale, you are here on one count of reckless driving, expired tag, driving while license suspended with knowledge, and a civil infraction, failure to furnish proof of insurance. I do find probable cause for your arrest. Do you have the ability to hire an attorney?
I do not, Your Honor. I would like the appointed one.
All right. I'll appoint the public defender to represent you. I do see some criminal history, but I'll keep your bonds at 500 for each count. Yes, ma'am.
Okay, I was told that I have one that says no bond, because my dad tried to bail me out last night and he could not.
I didn't see that.
One moment, Your Honor. I'm also trying to find her PTR sheet. Some of the order I got from him was a little bit, I received them out of order, so I'm trying to find them.
Yeah, sometimes I think we get them alphabetically, but it's easier to put them in the take out of order list.
I'm sorry, Your Honor, I only got them like 15 minutes before calendar. So I'm trying to find Miss Hale's PTR sheet right now, and I cannot find it.
Okay, well, I can read it to you.
I found it, Your Honor.
Okay, thank you. So, let's see. You said your dad tried to bond you out.
Yeah, this is according to my 20-year-old son. I called him this morning and he said, yeah, Grandpa went to bond you out last night and they said one of your things has no bond.
I think that's probably due to the no proof of insurance.
That one gives me a...
Just hang on.
No,
On
I'm
the
so sorry.
923, the officer put a bond amount, but it's a civil citation.
Right.
And there was a...
And it says not NA.
Correct.
Yes.
That might have caused some confusion.
So you should have a total of $1,500 bond.
Okay, yes.
Okay, so for count 4, you're not held in custody on.
Oh, okay.
Just counts 1, 2, and 3.
Okay, oh, I understand. Yeah,
Because
that's...
one is a civil ticket.
Yes. Because first they told me 1,500, then they said 2,000. So that would be that fourth one that's, yes, okay, now I understand.
It's
Sort of.
1,500, and your next court date is October 11th.
I will definitely be here, absolutely.
At 1:30 with Judge Garagoslo.
Absolutely. So, just to be clear, I'm sorry. What if there's still confusion about the bond? How do I?
There shouldn't be, because there's something in the system that has a bond correction.
Okay, okay.
So,
Awesome.
saying that it's a citation, that it should not be 500.
Okay, thank you, Your Honor. Thank you.
Yes. Hey, good morning, ma'am. What is your name?
Johnny Lanou.
Okay, ma'am, you're here on one count of battery domestic violence. I do find probable cause for the charges. Do you intend on hiring an attorney?
I can't afford one right now.
Would you like me to appoint one?
Please.
All right, I'll appoint the public defender to represent you. All right, state you have a position as to the bond for Miss Leno.
Just one moment, Your Honor. Yes.
Did you, Mr. Dressler, have an opportunity to review these before coming to court this morning?
A little bit, Your Honor. Some, Your Honor. I did review most of the cases. I did review some of these cases last night, but I did not get a chance to review every single 923 now.
Well,
all right. Your Honor, I would leave that in the court's discretion. It does appear that she has one prior felony conviction for possession of controlled substance. Does not appear that there are any prior domestic violence offenses. However, with this, we would ask for Ms. Lanou that there be a no contact order issued and no return to the victim's residence, wherever that may be. And also that she not possess any firearms.
Okay.
Also, domestic violence conditions.
This is, I do see a battery on a law enforcement officer some time ago.
A long time ago, yes,
18
ma'am.
years ago.
Yes,
I do
ma'am.
see that. All right, I'm going to set your bond at $2,000. You're to have no contact with your boyfriend. no return to the residence. Do you need to go back there one time to get personal belongings? All right, I'll allow you to go back there one time with law enforcement to get personal belongings. Also, as an additional condition, you're not to possess or consume any alcohol, and no firearms, ammunition, or weapons. Okay?
Judge,
Yes.
defense would ask the court to set bond at pretrial release. She only has one prior conviction from 2008, no failures to appear, and the allegations that she open hand hit the alleged victim several times and threw food and a drink at him.
Well, I've appointed the public defender, so we can do one or two things. We can do a $2,000 bond and no consumption or possession of alcohol, or we can do pretrial release with random testing.
If I can have a moment?
Yes. Oh, okay.
Judge, she would prefer the pretrial release with testing.
All right.
And Your Honor, would still be asking for no contact with the victim, no return to the victim's residence.
Absolutely.
Except for law enforcement escort, no possession of any firearms. Considering this
Absolutely.
is
That would not change whether there's a monetary bond or pretrial release. So, all right, I'll release you on pretrial release. As conditions of your pretrial release, no contact with your boyfriend. No, that means not through Facebook, social media, anything.
Yes, ma'am.
You can go to the residence one time. No possession or consumption of alcohol or illegal drugs. And you'll be subjected to random testing at your own expense. And no possession of any firearms, ammunition, or weapons. Okay? You understand all that?
Yes, ma'am.
Okay. And so your next court date is going to be October 28th at 9 a.m. with Judge Friedland, and that will be in Titusville. Okay? All right, good luck to you. And then it looks like Lisa Peterson, number 37 on the docket, surety bonded. My voice is getting worse. Starting to sound like a gentleman. Okay, and then we have Lonnie Robinson. Well, Mr. Robinson, I've seen you 3 times for this. This is my 3rd time, and I saw you twice in 1 week.
No, you didn't see me twice in 1 week, Your Honor.
Okay. Well, I do find probable cause for your arrest for the charges. Do you intend on hiring an attorney?
Well, I have 2 private attorneys right now, but
So
I believe
you're gonna ask them to take care of this case?
I guess so, yeah.
All right. So just know at a later point, if you decide that you want an appointed attorney, you can ask at any time.
Well, you can appoint one until I figure out what's going on with
All right.
them.
Well, I can do that. I'll go ahead.
Your Honor,
Yes.
it appears that this incident did take place at the Brevard County Jail. This defendant has multiple serious felonies pending, including first-degree murder. I'd be asking if there is any bond, because all of these are non-bondable. For some of these are F1 PDLs, which don't entitle someone to a bond. We'd be asking that all of these bonds be revoked at this time, considering how many serious felonies there are. And this is another serious felony.
All right. Well, I'm going to deny that request. Doesn't mean that that does not preclude the state from filing a motion. I understand he has multiple of these charges. I've seen him personally. But he is entitled to a bond on this charge. But his first degree murder charge, I'm sure he's in on no bond. So So I will go ahead and appoint the public defender to represent you. And I'll set your bond at 5,000 on this one. And your next court date is October 14 at 8 a.m. in front of Judge Peacock.
Thank you.
I don't want to see you again with this charge,
You ain't gonna
Mr.
see me.
Robinson. Come on.
Not gonna see me again, y'all.
All right. Thank you. Okay. Good morning, sir. What is your name?
Jonathan Anthony Antosiak.
Mr. Antosiak. How are you doing? Not so good?
No,
I
not
keep
bad.
seeing you here.
It's been a little while.
Yeah, it has been a little while.
I've been here
You
since
gotta stop coming in here.
I've been here since I seen you.
You've been in here since the last time.
I trust
Yeah,
that.
so there's an allegation of a battery. I do find probable cause for your arrest. Do you have the public defender for your other cases?
Yes, ma'am.
No, Judge, he has Attorney Russo.
Attorney Russo.
Okay, so I'll appoint Mr. Russo to represent you on this case. So he's your attorney for all your cases. And your bond amount will be 5,000.
Your Honor,
Yes.
just for the record, it is represented on the PTR sheet, but this defendant is currently on felony probation for 3 different felonies. It appears that this will result in yet another violation of probation. So we would be requesting requesting a no bond hold at this time, or that any of those bonds that were given on the new felonies, because it appears there are 2 other battery by detainee charges pending. Would be asked that the bond be revoked on those 2 cases, and that the defendant be held no bond pending further proceedings because of the 3 pending violations of probation.
Does he have a bond on the BOPs?
Your Honor, I do not know.
If you could look that up and let me know, please, because that would make a difference.
Is there any way to find out how to drop those? Like if I could get them dropped?
Speak up a little bit.
Is there any way to find out how would I get those dropped?
The BOPs, well, you need to talk to Mr. Russo about that.
And like the batteries, because it was
Right.
all self-defense.
Right, I understand, and those are things that you would talk to Mr. Russo about.
Yes.
And if you have any mental health issues, you would talk to Mr. Russo about that as well.
Do I have any other court dates coming up? Can you tell?
Speak a little louder.
No, never mind. Excuse me.
Okay.
I was going to ask, do you have any other court dates? Do I have any other court dates coming up?
Yeah, I'm gonna get you one in a second.
Okay.
Your Honor, I'm trying to locate whether or not there is a.
All right, well, there's probably not, so I'm gonna set your bond at 5,000 for this case.
Okay.
And your next court date is gonna be, he does not qualify for AMA or JLA, is that correct?
Your Honor, not from what I can see, I did not notice any qualifying offenses on the priors that I have in front of me. It does look like there was a burglary of an occupied dwelling from 2021, but it appears that it was amended to loitering and prowling.
All right.
So I don't believe that would qualify, but there's an attempted burglary. There have been attempted burglary, 3rd-degree felony. Your Honor, does not appear to qualify as under AMA or JLA at this time, so no.
Okay.
But nonetheless,
So your next court date is October 21st at 8 a.m. in front of Judge Friedland. All right, good luck to you, Mr. Antosiak. Okay, good morning, sir. What is your name?
Good morning, Stefan Hatcher.
Okay, so it looks like you're here on 2 cases for bond surrender. So I'll go ahead and set aside and release your bonds and reset them as they were before. The $35,000 for the robbery, the $5,000 for the battery, $2,000 for the possession of cocaine, $5,000 for the resisting. Okay, and you already have another court date of October 8th at 9 a.m. with Judge Ballou. Okay?
I'm sorry, can you repeat that one more time?
October 8th at 9 a.m. with Judge Ballou.
The bond amounts, please?
Oh, do you want the total?
Yes, ma'am.
3540 $47,000.
Thank you.
Thank you, sir. Okay, we need to take a recess to get the next group.
Yeah, give us just a minute. We'll bring them
Okay.
in.
All right, court's in recess.
To represent you. So therefore, it's important to fill out the affidavit of indigency worksheets, okay? You do have the right to remain silent. Anything you say can be used against you, so wait and speak with your attorney in private about the facts of your case. Let me tell you, you have a federal right and a state right to remain silent. This is not your trial. I'm surprised how many times I cover court for these and people want to tell me things. This is not the trial. I determine whether there's probable cause based upon the affidavit filed by the police. So when you want to tell me that, Judge, I only had one beer, or the other person started the fight, or etc., you just help the state convict you. All right? So if I do ask you a question, it'll just be about your ties to the community or work or that sort of thing. You also have the right to be in contact with your attorney or your family by a telephone. Let me advise you, if you're here on a warrant, whether it's for failure to appear, violation of probation, etc., the judge who issued the warrant generally has already set the bond amount that you'll need to go before that judge in order to request that that bond amount either be modified or set. So I may ask you some questions about your ties to the community and that sort of thing. So it's very important you tell me the truth. Would you all raise your right hand? I'm going to ask you to tell me the truth. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you very much. Okay. Let's start with Miss Lee. Good morning, ma'am. Are you Miss Christine Lee?
Yes, I am.
You have one misdemeanor. You have one charge of driving under the influence. It's a crime that allegedly occurred in Titusville. I reviewed it. I'm finding that there's probable cause for that, and I'm going to appoint you an attorney. I'm going to make a bond condition that there's no drinking or driving while your case is pending, and I'll set your bond at $500, man. Okay?
Okay.
All right, thank you very much.
And it's, I just got to make a phone call and get my, because I've never been arrested before.
I see that. You have a very clean record. So you need to talk with family and friends about trying to make the bond amount, and you'll have court in front of Judge Freeland. It's already been said, okay?
Okay, so when would I be able to make a phone call?
That's going to be more.
That's a question for your officers and the people at the jail here.
Okay, thank you.
Thank you.
Just a police report, just step up to the mic.
Good morning, man.
Step up to the mic. Don't have to read it now, step up to the mic, listen to the judge.
I don't have my good glasses on.
It's all right, we're not reading it right now, okay?
Can you step up to the mic for me?
Ma'am?
Right here?
Are you Miss Radway?
Yes.
All right, good morning. You have one misdemeanor charge of driving under the influence. I reviewed the affidavit, and it alleges things like you may have been asleep or sitting at a green light for a long period of time, and that's what led to them stopping and talking to you. So the one charge of DUI, there's probable cause for that. I'm going to appoint you an attorney, ma'am. As a condition of your probation, no drinking or driving whatsoever while this case is pending.
Mm-hmm.
And I'll set your bond at $500, ma'am.
Mm-hmm.
Okay?
Mm-hmm.
Thank you.
Thank you.
All right, Mr. Edwin, come on back over here. Back where you guys
Here, ma'am. Copy your police report.
Good morning, ma'am. Are you Miss Hanko? Oh, I'm sorry. I missed one. Miss Harris. Kenesha Harris? All right. Good morning. So you're here on a warrant for violation of probation for a case in front of Judge Davidson. So it's not unusual for courts to set the bond condition as no bond until the person's back in front of me. Have Judge Davidson cut you a break, kind of. She set the bond at $10,000. So I'm going to reappoint you an attorney, and your bond condition is to meet the $10,000. Okay, ma'am?
You gotta talk about the VOP on
You
site.
got a bond on violation of probation, that's a good thing.
Yeah, but the VOP on site, I don't.
You don't have to worry about that, you got a bond on the VOP, you're gonna amend the affidavit to add the new law offense.
Yeah, but I ain't gonna be able to bond out.
Well, you're not gonna get overruled on a felony violation of probation, you have a
I
bond.
don't, no, I don't have a bond on the VOP on site.
Can I get a bond on the VOP on site so I can bond out? Because the only reason why I didn't get a bond on that because they didn't file on discharge. And my grandma just passed yesterday. Like, I'm stuck in here because they wouldn't give me a bond because they didn't file the charges on discharge. And that was from Tuesday.
Well, on the case in front of Davidson, it's $10,000. What are we talking about, Mr. Edwards?
The first charge, when I first came in.
Judge, I think she's referring to the new law offense, which I don't even think is in the affidavit, but the new law offense itself, I was presuming that she had already bonded out on that. I did not research that. I can do so.
Yeah, I don't have that in front of me.
Yeah, I don't either. So I'll give her some information for the Public Defender's Office, how to reach us, and we'll see what we can do.
Okay.
Certainly, if she's got no bond on that, and then she's got a bond on the VOP, I'm sure we can help her.
They helped me with, they left me with no bond on the VOP on site because they didn't file for this one.
We can help you with that, ma'am.
They ought to be able to do something on that, man.
There you go.
So we'll be able to do that before court tomorrow?
Before court tomorrow?
Probably not.
If you're willing to address it, and, well, I don't think we can address it because it won't be on the docket.
Right.
So I think they'll have to file a motion Monday, if everything she's saying is accurate.
All right, ma'am, so you have to be
I
in
need to
touch.
get out because my grandma just passed.
I understand that. These things always seem to happen at the worst possible time, but there's nothing the court can do. We're going to have to adjust that with the other judge.
Yeah, but they told me that when I come to magistrate, when I come in the morning to let you guys know so that you can address it.
It's not on the docket today, ma'am.
To tell you guys, that's why I'm telling you.
It's not on the docket today. We can address it next week. You have to speak to your attorney about it. I'll speak to him about it.
It's
Okay?
not what you just told me.
We got it.
Crazy.
Good morning, ma'am. Are you Miss Hanko?
Yes, I am.
All right, good morning.
Here's my badge.
So you have one charge of driving under the influence, allegedly involving a red Pontiac. Okay. I reviewed the affidavit. It establishes probable cause. I'm going to appoint you an attorney. I'm going to order as a condition of your bond no drinking or driving at all while this case is pending. And I'll set your bond at $500, ma'am. Okay.
Thank you.
Thank you, ma'am.
Here you go, ma'am. Just a copy of the police report.
Good morning, sir. Are you Jeffrey Marcan?
Yes, sir.
All right, good morning. So you're here on a violation of probation, and it's a warrant, and like I was telling the other lady, it's pretty common then for the court to set bond at no bond until you're back in front of them, and that's your condition. It's alleged both technical violations, but also a substantive violation by an additional criminal charge. So you have no bond on this until you're in front of your judge. Do you understand that?
All right.
Thank you, sir. I'm sorry, and I'm reappointing counsel for him. Thank you, ma'am.
How you doing, Your Honor?
Good morning. Are you Terrell Carpenter?
Yes, sir.
All right. Good morning, sir. So, Mr. Carpenter, you have two cases. All right. The first case is 2021 CF 26692. It's a warrant for a failure to appear. It's a warrant for failure to appear for your trial. So, like I've said, it's pretty common for the judge to issue the warrant with no bond, and that is your situation here. So I'm going to reappoint you an attorney, and you have no bond on that case. Then you also have case 2021 CF 44235. You got a charge of possession of the THC oil and no driver's license. And I reviewed that one. It involved, allegedly involved a Nissan Cube. So I'm going to find PC and appoint you an attorney. I want to set the bond on these, but I don't want you misled. You still have no bond on the other ones. You don't get out until that one's dealt with. But I want to set a bond, so in case you deal with that one, this one's not hanging you up. So on the possession of the THC oil, I'm going to set the bond at $2,000, and on the no driver's license, that's $500. You need to, as a condition, don't drive at all. You can't drive until you have a valid driver's license. Okay?
Got you, sir.
All right. Thank you, Mr. Carpenter.
Brandon? Dennis?
Yes.
Good morning, sir. Are you Mr. Hennies?
Yes, sir.
All right. Good morning. So you have one case, excuse me, and it's a DUI. It's alleged to be a DUI with 2 priors involving a gray pickup truck. And I reviewed the affidavit. There's a probable cause, and I'm going to appoint you an attorney. Can I hear from the state? And just reading the affidavit, how am I to know that he has 2 priors, and therefore the bond amount would be greater than the misdemeanor bond amount?
It does not appear from the affidavit that you would be able to make that determination.
Okay. Appreciate the candor. So I'm going to set your bond at $1,000, sir. All right. And no, as a condition, no drinking at all while you're driving. Okay.
Yes, sir. And can I just say one thing? Like, I was
Sir,
never.
Wait just a minute. Don't make admissions. You're ahead right now. You got a low bond.
Okay.
Don't say anything about what happened.
That's goodbye, sir.
Wellmaker?
Good morning, sir. Are you Mr. Charles Wellmaker?
Yes, sir.
All right. So, Mr. Wellmaker, you have one case, 2021 CF 44231, 2 charges. One is an aggravated assault with a deadly weapon during a domestic violence event, and the other is possession of a firearm or ammunition, electronic weapon by a convicted felon. I've reviewed those. Those are serious charges, and there's probable cause. I'm going to appoint you an attorney. It's involving domestic violence, so you cannot return to the residence. Well, there's one exception. You can return one time with a police officer, and that's just to pick up clothing and toiletries. It's not to pick up the Game Boy or anything else. It's 2 minutes in and out, clothing, toiletries. Otherwise, no return to the residence, no contact with the victim or the children, no possession of any firearms while these cases are pending. And the bond on the aggravated assault is $20,000, and the bond on the possession of a firearm by a convicted felon is $15,000. Okay, sir?
Yes, sir. So how much that be back?
35,000. 3,500 gets you out. Willing? Cornelius, okay, step on up, I'll get it to you once you get up here.
Hey, good morning, sir. Are you Cornelius Lee?
Yes, sir.
All right, good morning. You have 2 cases. Let's talk about the first one. First one is 2021 CF 23889. It involves allegations of burglary or conveyance, grand theft of property, and fraudulent use of a credit card. All right. And it allegedly involves an ATM machine at a side of 7-Eleven. Okay. So I reviewed it, and I find there's probable cause. I'm going to appoint you an attorney. As a condition, I'm saying do not return to that 7-Eleven or have any contact with the people at the 7-Eleven or any credit card owners. Okay. And the bond on the burglary is $7,500. Grand theft is $5,000, and fraudulent use of a credit card is $5,000. That'd be $17,500 total on that one. Now, your second charge is 2021 MM, which is misdemeanor, 44218, and it's a violation of an injunction for sexual or dating violence, and it comes generally as a no bond situation. I've reviewed it because of where they got you was a violation of that injunction. An injunction entered in February of this year. So I'm going to find PC and appoint you an attorney. And again, you cannot go back to that place or be around it. Hold on a second. And I'll set bond at $1,000 on that one.
So I have a bond?
I'm giving you a bond on it. Yes, sir. So it's $1,000 on this one and it's $17,500 on the others, okay?
So, okay.
Okay, good luck, sir.
I checked on the injunction, it's still active.
I'm sorry, it's no return, no contact, etc.
I double checked.
Thank you.
I can't do the math on that right now. Maybe in just a minute I can. Okay?
Good morning. Are you Joseph Malone?
Yes.
All right, good morning, sir.
Morning.
All right, so you have one case, sir, and it involves an alleged DUI and some of the facts of the refusal to do the field testing stuff and the breath test. So I reviewed it. You're going to find there's probable cause. I'm going to appoint you an attorney. As a condition of your release, you need to not have any drinking or driving, no drinking at all when you're driving. And I'm going to set your bond at $500, sir.
Okay.
Be sure to make the court.
So what happens? You can just telephone if you want to bond out, you can bond out, contact a family member. Oops. Drop some? I'm having problems with these shoes. I understand. I can speak to you later if you'd like to. Okay.
Hey, good morning, sir. Are you Gregory Centeno?
Centeno, yes, sir.
All right, good morning. Thank you.
Good morning.
You have one case, one charge. It's driving under the influence. It also, some of the facts alleged are a refusal to do testing and etc. I'm going to find there's probable cause. I'm going to appoint you an attorney. As a condition, no drinking whatsoever if driving. And I'm going to set your bond at $500. Okay?
Okay.
All right, be sure you make it court.
All right. Thank
you,
you,
sir.
I will.
Your Honor, we almost have the entire next group in. We're just bringing one more down right now.
All right, thank you very much.
Thank you, sir.
5,000. All right.
Yes, sir. If you have a question, you can ask me. What can I do for you, sir? What's your last name? Kegley? Yeah, I'll see what I can do. The bad news is they get you on violation of probation for a technical violation. The good news is just don't forget well, you mean you've already had a violation of probation and you've already bonded out on it? No. It's on a different case. I'll see if I can check into it for you.
All right, call a break, call a break. I had seen, are we on the record? We can go off right now.
Thank you.
You good to go, Ms. Edwards?
Yes, sir.
All right. All right, good morning, ladies and gentlemen. My name is Judge George Paulk. I'll be here this morning to deal with initial appearances with you. Let me tell you what this hearing is about. The purpose of the hearing is to determine whether there's probable cause for your arrest. If there is, then what your bond should be and whether an attorney should be appointed to represent you. So it's important that you fill out any affidavit of indigency paperwork so we can appoint you an attorney. Please know you have the right to remain silent. This is both a federal right and a state right. These matters are being recorded and anything you say can be used against you. So wait and speak with your attorney in private about the facts of your case. The court may ask you some questions. If I do ask you questions, it's generally going to be about work and ties to the community. So this is not your trial. This is just a hearing where I look at the policeman's affidavit and see if it establishes probable cause. So I'm always surprised when I come to these handled court for my weekends and people tell me, Judge, I only had 2 beers, or I didn't start the fight, the other guy did, or you know, some sort of fact that it helps establish that you were there or you were involved and the police arrested the right person, and you've said all sorts of things that helps the state prove your guilt, and there's nothing I could do about it anyway. So please exercise your right to remain silent and don't tell me anything about the facts of your case. You have the right to be in contact with your attorney or family by a telephone. You need to speak to the jail if you're having any difficulty with that. And let me also advise you, a lot of people are here on a warrant. And whether it's for failure to appear, violation of probation, etc., the judge who issued the warrant has already set the bond amount, and you generally need to go before that judge in order to request a modification of the bond amount. All right. So if I do ask you questions, it's very important that you tell me the truth. So let me ask you to raise your right hand and swear to tell the truth. Do you swear, affirm, tell the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you.
You got Mr. Lanier. Let me see what I can do for you. Step on up. Sorry?
Sir, are you
Step
David
on up.
Lanier?
Yes, sir.
All right. Good morning, sir. So you caught a break. You're here on one case.
Yes, sir.
And it's for failure to appear at your arraignment on a petty theft case. And instead of the judge, like they historically did, say 2 or 3 years ago, it's just automatically no bond.
Yes,
your
sir.
judge set your bond at $250.
Yes, sir.
So that's a good low amount. So
Yes,
I'm going to reappoint you an attorney, and that's your bond. Don't miss court with Judge Silverman again, because it'll keep going up. Okay?
It will do me no good at this time to tell you why I missed the court appearance.
It won't. There's nothing I can do about it, and you would be saying things that could be used against you. All right? So meet your bond and make your court. All right?
Get my copy of this one. Sir, if you can't post that bond, give us a copy. Give us a call, and we'll see if we can get you a bond here. Okay?
Yeah, I can't do it until the.
Sir, are you Mr. Maliki Howard?
Malachi Howard, yes, sir.
Malachi, thank you, sir. All right, you have one case, 2021 CF 44057. It's a charge of robbery of a firearm, deadly weapon, or other weapon. I reviewed that because I was a judge this week issuing warrants. So there's probable cause, and I'm going to appoint you an attorney. I see you have a decent record, and as a condition of your condition of your release, you have no possession of any firearms while the case is pending. And I'm going to set your bond at $2,000.
Yes, sir.
All right, Mr. Howard.
Thank you.
Good morning, sir. Are you Riley Keith?
Yes, sir.
All right, Keith Riley, thank you. So you have a Habeas for breach of the peace, disorderly conduct, 2020 misdemeanor case. I think this is the one that Mr. Edwards was speaking about earlier.
That's correct.
And the bond was set by the judge issuing the Habeas at $1,000. And it was based upon motion filed in front of the court, and comes to me as an order from a judge with authority to issue that order, setting the Habeas at $1,000. So I find there's probable cause. I'm going to reappoint you an attorney, and your bond is $1,000, sir. Okay?
Yes, sir.
Are you Mr. Robinson?
Yes, sir.
All right. Good morning, sir. Step up a little closer. You have 3 cases, sir. And your first one is a 2018 CF being felony, 19747 case involving grand theft, possession of cocaine. And you're here for violating probation on that. And Judge Crawford already reviewed it and set bond at $5,000, which I'll tell you, I was a little surprised. Normally, Judge Crawford would do no bond, but he set your bond at $5,000. So I'm going to reappoint you an attorney, and that's your bond amount. Similarly, you have case 2018 CF 37706. It's 2 grand theft charges, and it's you're here for violation of probation on that case. I'm going to reappoint you an attorney, and Judge Crawford gave you bond, and again, he gave you $5,000. All right. So you'll be able to get out if you can post these. And then finally, Mr. Robinson, your third case is 2018 CF 40048. It was underlying charge was uttering forged bills or checks, drafts, or notes. You're here for violation of probation on that case, and I'm going to reappoint you an attorney. And again, Judge Crawford gave you a bond of $5,000 instead of no bond. So I'm going to appoint the attorney, and your bond will be $5,000 on each of those 3 cases. Be sure you make court with Judge Crawford. Okay. All right. Thank you, sir.
Okay, Mr. Wright. Just a copy of police report. You're welcome.
Are you Willie Wright?
Yes, sir. Good morning.
Hey, good morning, sir. So you have two cases here. Now, the first one is a 2021 CT 19168. It's failure to appear for a traffic arraignment on an underlying charge of driving while license suspended or revoked. And I'm going to reappoint you an attorney, and your bond on that was set at $500. And then the second case you have is 2021 MM, which means misdemeanor, 44228, and that's an alleged resisting arrest without violence. Don't tell me anything about the facts, but sometimes people don't realize resisting arrest without violence can be given the wrong name, running away, all those sort of things fall under the rubric of resisting arrest without violence. That's what's alleged here for an incident at Merritt Island Wildlife Refuge. So there's probable cause for that, and I'm going to appoint you an attorney. I'm going to set your bond at $250. Be sure you make a court with Judge Freeland, sir. Okay?
Savage?
Are you Mr. Warren Savage?
Yes, sir. Good
All
morning.
right, good morning, sir. All right, you're here and you have on the case 2021 MM, which is misdemeanor, 44219, but you have four charges, which is violation of an injunction for protection, two of those charges, and violation of your pretrial release conditions for the original domestic violence arrest. This is a misdemeanor, but it's a serious matter, probably one of the more serious misdemeanor matters we have.
Can I talk?
Don't make statements about that.
And I know it involves domestic violence, so there's always a lot of story to it. Again, you don't do yourself any favors by telling me that story.
But I would like to.
You don't need to do that. Don't do that.
Please save it for your attorney and for the judge who can do something about it. I'm here based on the affidavit and just that. It's not, I'll look at the affidavit and hear what you say and decide who's telling the truth. It's not that. That's what a trial is.
Okay.
This is, I just reviewed the affidavit. It doesn't meet the requirements. It does.
But I would like to.
All right. So let me finish my piece, and I'll see what you want to tell me.
Okay.
There's probable cause. I'm going to appoint you an attorney. This is an injunction on 9/1/21 and $1,000 bond for each of the charges. All right. So if you really want to tell me something, Ms. Savage, go ahead.
I do, sir.
Just for the record, Judge, I'm advising you don't need to say anything about the fact. It's not going to help you here.
I know. I just would like to, please. Okay, Your Honor. When they arrested me, I'm not familiar with this court system. I didn't know what they expected. I was in jail. I went to court the other day, and the lady judge explained to me everything. Now I know what they want here, and I didn't know nothing before. I'm dumb to courts, and I'm going to be on an ankle monitor. I'm no threat to nobody. I promise you, I will not do nothing wrong.
Okay.
I know this. I know what they want now.
Okay.
So.
Well, that's good. So that hopefully I'll take those statements as to indicate that you have a desire not to violate anything.
I'm not going to violate nothing, sir.
Okay. All right. Well, good luck to you, sir. Thank you. No, 1,000 each. 1,000 each. 4,000 total. Are you Mr. Brandon Kegley?
Yes, sir.
All right. Good morning, sir.
Good morning.
So you have one case, 2021 CF 15419. It's originally an underlying grand theft of a motor vehicle charge, but you're here for a violation of probation, and it's a technical violation, something you can talk to your attorney about. But the judge who issued it for a $1,000 bond. So you meet that $1,000, and I'm going to reappoint you an attorney. And good luck to you, Mr. Kegley.
Judge, if you could just hear me briefly on Mr. Kegley's case.
Will.
So it appears, according to EFACTS, Mr. Kegley actually has two felony cases that he's on probation for. The crux of the violation for both cases relate to a new law offense. The other case, just for the record, is 2020 CF 15422. He was on-cited, if you will, as to that violation of probation. In other words, the day that he got arrested for the new law offense, he was brought to jail, on-cited. Judge Ryman, it looks like Judge Ryman signed the order, and in the order it says she takes no action as to bond. Now, as to this particular case, I guess it just didn't catch the docket that day, so there was no actual, the bond was not actually addressed on this one. I'm asking you if you could, Judge, as to that other case, and I hope this doesn't disrupt or interfere in any way with the clerks, but on 2020 CF 15422, I'm asking that you also issue a bond on that. I agree the bond that he has on the case that's on the docket today is reasonable, but I would also ask that he get a bond on the other case, because I think that's what was contemplated.
2021 CF 15422?
That's what I showed, Judge, if I wrote it down right. Am I right on that, Kara? I didn't hear what you said.
There's been an affidavit and a violation report filed on that other case, so I suspect a warrant's going to be coming.
I saw that.
So I don't know if it's...
So maybe they'll issue a warrant that has a bond similar to this.
Right. So I'm going to take no action on that.
Okay.
I appreciate that, Mr. Edwards.
Thank you, though, Judge.
Thank you, Mr. Kegley.
Sir, it may be a couple days they'll get that warrant sent out. We hope it's got a bond on it, and be able to bond out on both cases. Once the affidavit is issued, then it's long for the warrant to get issued, so it shouldn't be long. Yeah, it's just procedural. You'll get a violation of probation warrant, okay? And that warrant will probably have to bond. Okay? Then you can bond out.
Good morning, sir. Are you Mr. Daniel Coons?
See.
You have two cases here.
Mm-hmm.
One is 2021 CF 44225. The CF means it's felony.
Mm-hmm. Yeah, I know. I figured that's
let me say this. I read your affidavit, and I think the state and public defender and I might talk about it a little bit. You need, and in reading it, I can see where you would maybe want to tell me a whole bunch of stuff. You need to remain silent.
See.
Okay. So there's a charge for threats or extortion in this case, and trespassing a structure or conveyance after a warning.
Sir, am I allowed to speak?
No, don't do that right now. Let me speak for you first. I think I'll be able to help you. I think the court will help you, so just let us go first.
So, as to trespass, is it defense going to be heard on trespass, when there's trespassing?
You know, Judge, the heart of my argument as to his case is going to relate to the extortion. As to the trespass itself, I mean, it does indicate that there was some sort of warning. That
Trespass
was given.
warning November 23rd of 20. So
correct.
It seems to me there's PC on the trespass.
Right. I don't really have an argument as to that as far as PC. I mean, I'd like to see.
What's the argument on the felony extortion on the $40, or I'm going to throw a beer bottle?
Sure. As to the extortion, Judge, it wasn't clear to me that he was the person that actually
given to a third party, and then allegedly the third party sent it to the victim.
Right. And I don't know if if you send a text to one person and that person on their own sends it to somebody else. I don't know necessarily that there would be an intent there.
If he told them to, then that'd be another thing. But the affidavit doesn't tell me that.
Right. Exactly.
Right. State, Ms. Campbell.
Hold on one second.
Yes, sir. And then that may also relate, criminal mischief is going to be throwing the beer bottles.
No argument as to PC on that.
Well, Your Honor, I believe, when you look at the 923 for the misdemeanor on the beer bottles, the defendant does admit that he threw the beer bottles at the neighbor's house, admitting that he wanted to wake everyone up.
Yeah, I agree. Even the defense agrees. There's PC on trespass without debate. In my mind, there's PC on the criminal mischief without debate. The question I have is on the extortion. and the relaying by a third party of a threat, or alleged threat.
Yeah, I believe you could find that probable cause that he committed extortion, whether or not he did it himself or employed someone else to extort his neighbor to give him the $40 or whatever the agreement was. I don't think it matters that he does it or if he has a henchman.
I agree with you, Ms. Carroll. And you know, I've put that in orders before. Don't have any contact, and don't use an agent to have contact. But doesn't the affidavit need to tell me that, give me some indicia that he told this third party to send it? Either he directed it or he told him to, or some indication. And without that indication, don't have a problem here today saying, yeah, there's PC that he made this threat because he directed the third party to send it.
I think the court could find that he directed the threat to be made.
Okay, appreciate that. And what I'm going to do is my reading of the affidavit. I'll check it one last time.
You're doing good right now. Okay, just stay status. Don't say anything. You're not going to have to speak.
My reading of the affidavit doesn't allow me to make an inference that the affidavit doesn't say that he told the third party to send it.
That's the point.
And reading the affidavit doesn't allow me to make a reasonable inference that he told the third party to send it. So I'm gonna not find PC on the felony extortion.
Thank you, Judge.
All right. What's the best way to handle that for the state? So there's PC on the trespass, so it's 500 and appointed attorney and no contact with the victim and no contact with any third parties and directing them to contact the victim, and no return to that residence. And then on the second, the criminal mischief, there's probable cause for that, and I'll appoint an attorney, and that's a $500 bond too. On the threats and extortion, I'm finding no PC and an ROR bond. Thank you. That's exactly
Thank you,
what I was
Judge.
looking for. Thank you. All right. Thank you, Ms. Coombs.
Can I speak up about something?
No, you don't need to. Just speak to me. Okay?
That wouldn't be wise, considering you're going to tell me something I'm going to...
No disrespect, sir. No disrespect.
Well, I'm not worried about the respect. I'm worried about you saying something that might...
I'll say something to you. Have a seat right here and I'll talk to you, okay? Have a seat, don't mind.
All right, thank you.
Personal. Give me a little distance.
All right, we'll go off the record. Or let me ask one other thing. Because we're on Miss Kanisha Harris.
Thank you for letting me stand up.
Ms. Harris was saying that the other case that's not in front of me, that it was no bond. That's what I'm reading into it. And that's no bond, kind of by mistake. And this is the, well, I see